Act 1971, a meditation on untapped possibilities. And this presentation was written in collaboration with Casey Hardison and explores his legal journey, having been arrested in Brighton, in Caroline's constituency, in 2004 for the production of psychedelic drugs in his spare bedroom laboratory. And I want to present for him and to discuss the key insights produced by his subsequent 7-year meditation on the structure and purpose of the Misuse of Drugs Act 1971. And as Cara has just flagged up, on the perhaps surprising role that the Act that's central to our current system of prohibition might play in a post-prohibition world, or at least in helping us to get to that point. I'm using Casey's story as a vehicle through which we can gain a better understanding of the untapped possibilities of the Act, and I'm also hoping that bringing this human story in will help ensure that this rather technical argument isn't overly dry, so fingers crossed. So, upon arrest, Casey was faced with a choice. He could either roll over and put his hands up and receive lesser, though still admittedly significant punishment, or he could stand up for his beliefs. Casey chose to stand up for cognitive liberty, the right to alter one's mental functioning as one sees fit. However, as regards how he would do this, he had the problem that he knew next to nothing about the principles of English law, nor how our UK court system works. So he had to self-educate on these matters with a very, very limited prison library, no internet access, and basically no relevant court judgments or precedents to follow. So he set about constructing his argument from first principles, and he soon realised that the right to cognitive liberty equated with Article 9 of the European Convention on Human Rights, which protects freedom of thought in this country. So charged under the Misuse of Drugs Act with 9 counts of producing and supplying LSD, 2CB, DMT, MDMA and mescaline, amongst others, all psychedelic Class A drugs. Casey initially mounted a human rights-based argument, telling the court that he would run his own case on the basis that his right to freedom of thought was being infringed in a discriminatory manner by the Misuse of Drugs Act 1971. And his trial began with a 10-day presentation of his arguments to the judge, where the judge decides which arguments you're allowed to put before the jury. And so he passionately argued around the fundamental principle of what it means to be truly free to explore one's own mind. The judge shot down these arguments and forbade him to raise them before the jury. And he told Casey to show him the black letters of the law, the significance of which advice would only truly kind of sink in with Casey over the long years ahead. So an 8-week trial followed, in which Casey tried to kind of slip into his cross-examination of the officers, customs agents, forensics experts, and into his own evidence, the ideas of better living through chemistry, of cognitive freedom, and the fact that somehow, by sleight of hand, Western governments had been able to declare off-limits to personal exploration what he considered to be 2 of the most important chemical pathways of the human mind. As the trial ended, Casey asked the jury to acquit him, and in doing so to help him end the war on some people who used some drugs. They did not. In April 2005, Casey was sentenced to 20 years imprisonment. Undeterred, he undertook further study of the Human Rights Act as he prepared for his appeal. But strangely, he'd yet to look at the black letters of the Misuse of Drugs Act himself. He'd kind of made up his mind that this act was the problem and it had to be declared contrary to human rights. So his appeal hearing was set for May 2006, and in the meantime the public conversation about drugs began to shift, with the then Home Secretary Charles Clarke making a promise to Parliament and to the public. And Charles Clarke said that in the next few weeks I will publish a review, a consultation paper with suggestions for a review of the drug classification system. Unfortunately, this consultation paper and review would be shelved when the Home Secretary was forced to resign a few days before Casey's appeal, but I'm going to return to it later. So, in applying for leave to appeal, Casey again pled his case on the fundamental philosophical and political level of what it means to be truly free. And he stated his appeal on the ground that with respect to autonomous determination over the inner workings of each person's mind, the values of tolerance and respect are far weightier and far more conducive to the basic principles of democracy than is the discriminatory policy of prohibition currently invoked. The court's response was somewhat predictable, and Casey was refused leave to appeal against his sentence. Just a little bit more policy-based context, and this was the report that David Cameron kind of fed into that Caroline mentioned earlier, where the House of Commons Science and Technology Committee investigated our drug classification system under the Misuse of Drugs Act. and published drug classification, making a hash of it as a result of that investigation, in which they said, with respect to the drug classification system, we have identified significant anomalies in the classification of individual drugs and a regrettable lack of consistency in the rationale used to make classification decisions. We have concluded that the current classification system is not fit for purpose and should be replaced with a more scientifically based scale of harm. And then they continued that one of the most striking findings highlighted in the paper drafted by Professor Nutt and his colleagues was the fact that on their basis of their assessment of harm, tobacco and alcohol would be ranked as more harmful than LSD and ecstasy, both Class A drugs. And so this paper referred to here, produced by Professor Nutt, was later published in The Lancet. And in the scientific expert's opinion, and completely going along with what Matt was saying, that these are the people that we should be listening to on this, they said, in a quote from them, they said that our results emphasise that the exclusion of alcohol and tobacco from the Misuse of Drugs Act is, from a scientific perspective, arbitrary. So, in light of such findings, Casey questioned why he was serving 20 years in prison whilst board members of British American Tobacco sat in government or parliament. And with this question, Casey began to see his legal argument in terms of the common law principle that the law should treat people equally unless a rational and objective basis existed for doing otherwise. An insight into the official explanation for this discrepancy in treatment was given in the government's reply to drug classification, making a hash of it. And in response to the suggestion that alcohol and tobacco should be ranked alongside other common drugs of use under the Misuse of Drugs Act, but decoupled from penalties, the Home Secretary said the following. So, the government believes the classification system under the Misuse of Drugs Act 1971 is not a suitable mechanism for regulating legal substances such as alcohol and tobacco. The distinction between legal and illegal substances is not unequivocally based on pharmacology, economic or risk-benefit analysis. It is also based in large part on historical and cultural precedents. A classification system that applies to legal as well as illegal substances would be unacceptable to the vast majority of people who use, for example, alcohol responsibly, and would conflict with deeply embedded historical tradition and tolerance of consumption of a number of substances that alter mental functioning. Legal substances are therefore regulated through other means. However, the government acknowledges that alcohol and tobacco account for more health problems and deaths than illicit drugs. And it's kind of instructive to work through the governmental justification and break it down and look at the claims that they're making here closely and ask some fundamental questions. So first of all, this idea that the Act is not a suitable mechanism for regulating alcohol and tobacco. And to ask the question of whether or not the Act is really unsuitable, or has the Home Secretary perhaps misconstrued and misunderstood the Act? And our key argument is that they have, and I'll be developing this. Also, just focusing briefly on this phrase, legal and illegal substances. It's worth noting that the Act doesn't actually make substances legal or illegal, but rather the actions of people associated with them. We're controlling people, not drugs, and we would do well to always remember that. And also this admission that the law is based in large part on historical and cultural precedents. I mean, that isn't acceptable. Isn't the law neutral or supposed to be? These aren't relevant legal grounds for not applying a law generally and equally. If we followed historical and cultural precedents over the years, we would have continued to deny women the vote and kept homosexuality a crime. It's not a lucid argument. This argument that a classification system that applies to legal as well as illegal substances would be acceptable to the vast majority of people who use, for example, alcohol responsibly, and would conflict with deeply embedded historical tradition and tolerance of consumption of a number of substances that alter mental functioning. So a crucial question in relation to this is, does the Act mandate prohibition? Or is the Home Secretary confusing control with prohibition here? Presumably so, because otherwise, why would they think that it's unacceptable rather to classify alcohol and tobacco? And what I'm going to argue is that the Act is much broader potentially than a simply prohibitive mechanism. And also, why is this closely guarded, long-standing tolerance of altering mental functioning and acceptance of the possibility of responsible use not extended to the consumption of other psychoactive substances, with the result that alcohol and tobacco are therefore regulated through other means? And is this rational, or even indeed what Parliament originally intended with the Misuse of Drugs Act? So the government acknowledged that alcohol and tobacco account for more health problems and deaths than illicit drugs. Then why are they not controlled drugs? And why are those who produce, commerce and possess these drugs free from regulation by the Act? And is this arbitrary, unequal treatment? So to help answer these questions, I want to turn it, as Casey did at this juncture in his legal journey, to the black letters of the law of the Misuse of Drugs Act itself and see what we can discover. So an act to make provision with respect to dangerous or otherwise harmful drugs. And Section 2 defines controlled drugs and their classification for the purposes of the Act. For our purposes, importantly, the Home Secretary is the gatekeeper of the control and classification mechanism. And the process begins with either a recommendation to the Home Secretary from the Advisory Council or the Home Secretaries actively consulting the ACMD themselves. So after creating the ACMD, the relevant part of Section 1 states that it shall be the duty of the Advisory Council to keep under review the situation with respect to drugs which are being or appear to them likely to be misused and of which the misuse is having or appears to them capable of having harmful effects sufficient to constitute a social problem, and to give advice on measures, whether or not involving alteration of the law, which ought to be taken for preventing the misuse of such drugs or dealing with social problems connected with their misuse. So when Section 2.5 is read conjunct with Section 1.2, the Home Secretary has a duty to consult the Advisory Council on the possibility of controlling a drug under the Act whenever the following facts are established. So a substance is being self-administered as a drug, the drug is being misused, the misuse of the drug is having harmful effects, the harmful effects are sufficient to constitute a social problem. And these criteria for action most certainly do apply to alcohol and tobacco. And these are just quotes from the government themselves in the past few years in relation to alcohol and tobacco. So saying that alcohol and tobacco are substances that can be misused, alcohol and tobacco pose health risks and may have antisocial effects. Alcohol and tobacco account for more health problems and deaths than controlled drugs. For instance, in terms of death, controlled drugs amounted to 1,388 in 2003, compared to about 20,000 for alcohol and 100,000 for tobacco. Another important fact about the Misuse of Drugs Act, as I said, it regulates people involved in production, supply, possession and cultivation of drugs, all of which regulation contain the magical phrase subject to Section 7. So Section 7, authorisation of activities otherwise unlawful under foregoing provisions. So the Secretary of State may, by regulations, except from Section 3 or 4 or 5 of this Act. So these are the sections which create the offences of possession, supply, etc. Such controlled drugs as may be specified in the regulations, and may make other such provision as he thinks fit for the purpose of making it lawful for persons to do things which under any other provisions of this Act it would otherwise be unlawful for them to do. Without prejudice to the generality of paragraph B of subsection 1 above, regulations may in particular provide for the doing of that thing to be lawful if it is done under and in accordance with the terms of a licence or other authority issued by the Secretary of State, and in compliance with any conditions attached thereto, or if it's done in compliance with such conditions as may be prescribed. Thus, the Home Secretary's power to prescribe under Section 7 which of the offences in the Act apply to which controlled drugs makes possible a plurality of regulatory regimes not limited to so-called prohibition. Section 7 makes clear that legitimate activities with controlled drugs were not intended to be limited to medical, scientific or industrial use only, which is the restrictive way in which Section 7 is currently deployed. Indeed, following the black letters of the law, the only requisite for legitimate use is the Home Secretary's authorisation under Section 7. Looking to Section 22 holds other surprises. Here, under Section 22, the Home Secretary can exclude the application of any offence. This is an exceptionally wide power. If the Home Secretary recommended and Parliament approved, personal possession of controlled drugs, for instance, could become lawful without the need for legislative change. This leaves aside our international obligations, of course, but for those of you who were here last night, as Amanda Fielding said, the International Drug Conventions were not written on tablets of stone by God, and the Beckley Foundation are putting forward proposals for a new draft convention which will hopefully move us forward. And the real clincher is found in Section 31, where it's saying that regulations made by the Secretary of State under any provisions of this Act may make different provisions in relation to different controlled drugs, different classes of persons, different provisions of this Act, or other different cases or circumstances. Thus, contrary to the government's assertion, the Misuse of Drugs Act, specifically Sections 7, 22 and 31, when read together, appear a very suitable mechanism for the flexible regulation of action with respect to any dangerous drug. With them, the Home Secretary could control and classify alcohol and tobacco under the Misuse of Drugs Act, allowing the public to get a sense about the relative harms of other controlled drugs, whilst using the flexibility of the Act to allow for their continued use. Indeed, the Misuse of Drugs Act allows for the implementation of every regulatory model found within Transformed Drug Policy Foundation's rightly celebrated blueprint for regulation, without the need for any new primary legislation. And this, we argue, is the untapped possibility of the Misuse of Drugs Act. And the Home Secretary knew this in 2006 when the review of the UK drug classification system was shelved. Casey managed, after a laborious freedom of information request process, to see what the review document had contained. And strikingly, it had said that in view of the harms presented by alcohol and tobacco, a classification system could recognise these substances in a way which would stop short of imposing comparable controls. The creation of a system to assess the harmfulness of drugs on a more structured and transparent basis could be extended to cover alcohol and tobacco, but for comparative and messaging rather than control purposes. This approach would allow for a more logically consistent approach to substance misuse. However, most people would not want to see the drug classification system as a mechanism for regulating legal substances such as alcohol and tobacco. If applied to legal as well as illegal substances, this would conflict with deeply embedded historical tradition and tolerance of consumption of a number of substances that alter mental functioning. So there it is again, and you end up with this ironically shared central concern of the government, of Casey, and indeed of myself, the right to alter mental functioning, also known as cognitive liberty. After seeing these words, Casey requested that the Home Secretary exercise her discretion to consult the Advisory Council on the possibility of bringing alcohol and tobacco under the Act's control. Naturally, were this to happen, and clearly this is the driver in us pushing for this, a question would arise. If alcohol and tobacco can be used, possessed, supplied and produced under the Act, why can't other controlled drugs that cause far less harm, such as cannabis or MDMA, for example? Predictably, the Home Secretary refused Casey's request that she consult the Advisory Council in relation to the possibility of controlling alcohol and tobacco under the Act, stating that the government's policy is to regulate controlled drugs, more commonly referred to as illegal drugs, through the Misuse of Drugs Act 1971, and the availability of alcohol and tobacco separately. This stance recognises that whilst alcohol and tobacco pose health risks and may have antisocial effects, their use is embedded in society and responsible use is possible and commonplace. And around we go. A hearing to determine permission for judicial review of the Home Secretary's refusal to consult the Advisory Council on the possible control of alcohol and tobacco under the Act was set for the 18th of November at the High Court. However, we were recently informed that the hearing had been cancelled and an extended civil restraint order had been imposed on Casey to stop him carrying this any further in the courts. They said that he was a vexatious litigant. The order said that the claim that the Home Secretary has a public duty to consult the Advisory Council in these circumstances is unarguable. The framework for the control of alcohol and tobacco is different from that for controlled drugs. Yet both the former Home Secretaries and the ACMD have declared alcohol and tobacco within the Misuse of Drugs Act's jurisdiction, and we can find no primary legislation that displaces it. At no point have the courts construed the legislation and unpacked these arguments. And I just want to finish with a quote from drug policy researcher Alex Stevens, which I think hopefully emphasises why attempting to use this approach to move beyond prohibition might prove fruitful. And he said that social changes that were once unthinkable have been repeatedly achieved in the past. They were not created by people sitting it out, waiting to see how bad things would get. They did not rely on the total overthrow of existing social arrangements. They were created by people joining together, organising and voting for change. This is an effort of the imagination as much as it is of will. If we are to create less harmful ways of dealing with drugs, then we need to shift the mental and institutional boundaries of the present. Thank you. And so he passionately argued around the fundamental principle of what it means to be truly free to explore one's own mind. The judge shot down these arguments and forbade him to raise them before the jury, and he told Casey to show him the black letters of the law, the significance of which advice would only truly kind of sink in with Casey over the long years ahead. So an 8-week trial followed, in which Casey tried to kind of slip into his cross-examination of the officers, customs agents, forensics experts, and into his own evidence, the ideas of better living through chemistry, of cognitive freedom, and the fact that somehow, by sleight of hand, Western government, with Article 9 of the European Convention on Human Rights, which protects freedom of thought in this country. So charged under the Misuse of Drugs Act with 9 counts of producing and supplying LSD, 2CB, DMT, MDMA and mescaline, amongst others, all psychedelic Class A drugs. Casey initially mounted a human rights-based argument, telling the court that he would run his own case on the basis that his right to freedom of thought was being infringed in a discriminatory manner by the Misuse of Drugs Act 1971. And his trial began with a 10-day presentation of his arguments to the judge, where the judge decides which arguments you're allowed to put before the jury. His subsequent 7-year meditation on the structure and purpose of the Misuse of Drugs Act 1971. And as Cara has just flagged up, on the perhaps surprising role that the Act that's central to our current system of prohibition might play in a post-prohibition world, or at least in helping us to get to that point. I'm using Casey's story as a vehicle through which we can gain a better understanding of the untapped possibilities of the Act, and I'm also hoping that bringing this human story in will help ensure that this rather technical argument isn't overly dry, so fingers crossed. So, upon arrest, Casey was faced with a choice. He could either roll over and put his hands up and receive lesser, though still admittedly significant punishment, or he could stand up for his beliefs. Casey chose to stand up for cognitive liberty, the right to alter one's mental functioning as one sees fit. However, as regards how he would do this, he had the problem that he knew next to nothing about the principles of English law, nor how our UK court system works. So he had to self-educate on these matters with a very, very limited prison library, no internet access, and basically no relevant court judgments or precedents to follow. So he set about constructing his argument from first principles, and he soon realised that the right to cognitive liberty equated Drugs Act 1971, a meditation on untapped possibilities. And this presentation was written in collaboration with Casey Hardison and explores his legal journey, having been arrested in Brighton, in Caroline's constituency, in 2004 for the production of psychedelic drugs in his spare bedroom laboratory. And I want to present for him and to discuss the key insights produced by